to warmly welcome all of you to this workshop. We are confident that today's session will not only equip participants with valuable insights for the upcoming Victor's Moot competition, but will also contribute meaningfully to your future journey in the legal profession. And today's workshop will be on oral advocacy and will specifically focus on the interplay between state authority and binding contractual obligations. Before we begin, I would like to encourage all participants to make the most of this opportunity by actively engaging with today's session. Mooting is a skill best developed through discussion, curiosity, and continuous learning. So please feel free to ask questions, seek clarification, and share your thoughts throughout the workshop, because your active participation will not only enhance your own learning experience, but will also contribute to a more engaging and productive discussion for everyone present. We are fortunate to have with us a resource person with extensive academic and professional experience. So I encourage you to take full advantage of this opportunity to learn from everyone. So once again, please feel free to turn on your cameras to ask questions throughout the session to make sure it's more interactive and engaging for everyone. Moving on to our resource person for today, we are honored to have with us Ms. Nayanthara Balapatabendi, who currently serves as a state counsel at the Attorney General's Department. Ms. Balapatabendi is an accomplished legal professional and a distinguished Chevening scholar, during which she earned a Master's at Law at the Durham University. And her academic achievements reflect her strong commitment to legal scholarship and professional excellence. She holds a Bachelor of Laws from the University of London and also a Master of Laws from the University of Colombo as well. And she's currently also an external resource person for the University of Colombo's Master's program. And we're extremely grateful for Ms. Balapatabendi for taking the time to share her knowledge and expertise with us today. So without further ado, it is my pleasure to invite Ms. Nayanthara Balapatabendi to commence today's session. Over to you, ma'am.
Hi, everyone. Thank you so much, Amani, for that very gracious welcome and introduction. Like Amani mentioned, I would love if everyone could be as interactive as possible. And if you can, you're more than welcome to ask me absolutely any questions that you'd like to know. So what I'm going to do is I'm going to start out with a few key theoretical points that you might want to keep in mind when you go through this whole moot process, specific to this moot question, and a few key principles you would want to keep in mind. And then afterwards, I'll maybe give you guys a few pointers on oral advocacy. And again, I just want to reiterate that when I speak, I am a state counsel. I work for the government of Sri Lanka, attached to the Attorney General's Department. And we do a lot of international commercial arbitrations, which are part and parcel of our role as state counsel. So a lot of what I say is going to be from experience, especially in terms of oral advocacy and what it means to be an advocate before an international commercial arbitration tribunal, and the kind of things you've just got to keep in mind. So a little bit of practical advocacy at the end of it, especially in terms of how you deal with the moot versus how you deal with it in actual real life. And please feel free to ask me absolutely any questions that anyone wants. So I'm having a bit of difficulty just getting I just did like a quick signposting presentation. I'm having a little bit of trouble pulling that up. But I will maybe be able to do this without that because it's not too heavy on detailed information. So the first thing I want to talk to you all about is the difference between international commercial arbitration, investor-state arbitration, or dispute settlement, as well as normal litigation in courts. Now, the Victor's Moot specifically talks about situations where you have a state authority and that state authority has entered into a binding contract or a legal agreement with some sort of private entity. And because they have entered into that contract with that entity, they now need to kind of resolve some sort of dispute that may arise. Now, the usual disputes that do in actual practice arise are situations where You have states who enter into agreements with private entities who are then afterwards not able to actually fulfill their end of the bargain, which is they're not able to perhaps pay the amount that they were supposed to pay. They are perhaps not able to end the contract, or they're not able to give effect to that contract. If you're Sri Lankan, you've seen this happen a lot before in actual fact. You've seen it with the Japanese light rail project. We've seen it with there are a lot more international contracts that we've entered into that have just not made the headlines, where the state has entered into the contract and for whatever reason been unable to perform their duties and obligations under it. Now, what I want to discuss is that there are very many types of dispute settlement in that kind of instance. If you have a bilateral investment treaty between the two parties, now, for example, there's a few, I think, energy projects that are trying to be entered into, and those are based on bilateral investment treaties. And if it is based on an investment treaty, if the contract you've entered into is based on a bilateral investment treaty, it doesn't fall within the scope of an international commercial arbitration unless specified in the contract. Usually it'll go to ISDS, which is the investor state dispute settlement mechanism, which is completely different and involves things like the most favored nation clause. It involves things like expropriation, and it's not very similar to the international commercial arbitration scope. The other mechanism that you have is obviously litigation in the country that either the company is in, or it's going to be litigation in the country that the state is based in. So, for example, you would have to, if I take the Japanese light rail project as an example, either it would be in Sri Lanka or it would be in Japan. Is that okay with everyone? Sorry, am I going too fast? Is everyone understanding? Just want to check in. All right, great. So the last one is the one that is relevant to you all, which is international commercial arbitration. Now, international commercial arbitration is something that is significantly preferred by parties, specifically very much preferred by the companies that enter into the agreement. The reason for this is very straightforward. Firstly, we already know things like the speed of it. Now, in actual practice, it might not always be as fast as is promised, but most international arbitration centers like the London International Arbitration Center or SIAC, which is the Singapore International Arbitration Center, those are extremely fast. They have extremely quick deadlines. And because of that, the process is a lot faster. When it comes to, so in terms of speed, the quickest mechanisms, and that's why most countries want to enter into one, and why most companies want to enter into it. The other thing is confidentiality, which again, something that you'll all know. The proceedings are confidential, so it's good for companies because they don't necessarily get screwed over when their confidential plans are marked as evidence, and everyone can see those, let's say if it's construction designs. And it's also good for states because they don't want to undermine investor confidence because a company has entered into their country and now they weren't able to give effect to that contract. Now, what I want to focus on a little bit with you guys is this concept of neutrality. Neutrality is one reason why corporations, companies, institutions love to enter into international commercial arbitration as a dispute resolution mechanism when it comes to states. Now, unlike a lot of other, like let's say, for example, if you're going to court, litigation in the most traditional sense of it, you are in a situation where you may have to deal with a bit of partiality and the court giving a little bit more prominence to the state party because they are the state party. Regardless of whether it's in the home country or in the foreign country, perhaps the state will get a little bit more preference over a company. On the flip side, if you were to enter into litigation in the home state of the company, perhaps the state would feel like they are at a disadvantage acting in a country that they don't understand, where they don't necessarily understand if the other country will give them that level of preference or not, or whether it would choose their homegrown company. Arbitration in industrial commercial arbitration is what we call party neutral. This means that in an international commercial arbitration, a state will never get preference just because they are a state. And having worked for the state, being someone who works for the state, I assure you, in actual real life, we would love it if the state got preference just because we are the state. But that is not something that happens. In an international commercial arbitration, parties are absolutely considered to be neutral. Now, I was very fortunate when I was in Durham to learn from one of the foremost professors who has done research into this idea of neutrality when it comes to international commercial arbitrations that involve states. It's a professor called Ronan Fihili, and he has written a fantastic article on what neutrality entails. I won't go into it a lot because this is not I was told this is not a very academic presentation and I'm not just going to be spewing law at you. But what I do reiterate is that when you do make your submissions at the tournament, at the Moot, please remember that if you are representing the state, you get no preference simply because you are the state. This is the case when it comes to the Moot, and this will also be the case when it comes to real life. The state will never get preference in an international commercial arbitration. The state is expected to be on a same level playing field as the company. Is that okay with everyone? And all of that entire principle of the state not being on an equal playing field, that concept, that principle is this principle called neutrality. The concept of neutrality breaks down even further. You have something called party neutrality and arbitrator neutrality. Arbitrator neutrality is where you make sure that on the basis of nationality, there is no party partiality. Neutrality is a bit different from bias. It's an objective standard. And it essentially means that you would ensure that there's no preference given to the state. So if you're appearing for the state, you're not at an advantage. And if you're appearing for the company, you're not at a disadvantage. Does that make sense to everyone? Okay. So then the question goes, okay, if it's level playing field, what exactly is the decisive factor? And more often than not, especially in construction arbitrations, we see that the most decisive factor is this concept of risk apportionment. You have to see who has borne the risk to obtain specific approvals or guarantees or loans or any other, I would say, clearances. You would have to read the contract very carefully and see who has obtained or who has borne the risk for that. And based on who has borne the risk, you are generally able to say the person who has borne the risk has to now bear the liability for it. But there is also a concept of, yes, above and beyond party autonomy, you can also look at who should have borne the risk. If it's not specifically set out in the contract, who is better placed to fulfill these obligations, and therefore who is better placed to bear this risk. Does that make sense?
That doesn't make sense actually. Could you please explain it again? I'm
Sure.
very sorry to interrupt.
No, please. All right. So basically, if, for example, one party is supposed to get an approval for something or has to get, let's say, has to obtain a bank guarantee in order to proceed with the contract, and they don't obtain that bank guarantee, or they have improperly obtained the bank guarantee, or the bank guarantee has been obtained with fraud or for something to that effect. And for the reason that that specific task that was set out in the contract was not given effect to, the contract cannot proceed. Now, if you're in a situation where the contract can then not proceed because of some specific act of some specific party, you then go on and look at who has borne the risk for the contract proceeding with or without this approval. Does that make a bit more sense?
Yes, it does actually. Thank you.
Thanks for the question. Really appreciate that to know someone is listening to me on a rainy morning at 10:30 a.m.
I have a doubt.
Yeah.
Yeah, thank you. So regarding the risk apportionment, the risks are itself like multiple, right? Some can be regulatory, like for instance, like you said, getting approvals and compliances. Some can be monetary and financial, like bank guarantees and all. And different parties would be taking up different risks. In that case, how do we balance and see which one is more riskier or like, has more weightage than the other?
Correct. So if I understand your question, it's just how do you ascertain who's bearing the risk for what? So that's actually very interesting. Usually in actual practice, who bears the risk is actually set out in, I would say, there are standards of conduct. For example, if it's a contract and it's governed by something like FIDIC, you would have who bears the risk set out in the book on FIDIC. Contrarily, you could also look at there's a lot of academic articles. We don't have a lot of case law when it comes to commercial arbitrations because everything's so confidential unless it's enforced. But you could look into precedent and check to see what's in this is if it's not specified in the contract. If it's specified in the contract, then parties have agreed that this is how the risk apportionment is going to proceed. So, for example, somebody is given specific duties to do, and if they fail to do those duties, you could argue that then they have borne the risk of the contract proceeding and then getting stalled partway because they didn't get the approvals properly. That is one argument. Then another argument is who bore the risk on the basis of who is better placed to fulfill those obligations. Another argument is whether the person who fulfilled the obligation was informed that it was fulfilled by the other party, but there was an error and whose fault it was for that error. So really the person, now let's say, for example, if you bear the risk, you bear the liability. You'll understand that concept. So if you take on the risk, if you say anything is a risk, right? There's an opportunity cost for everything. So if you bear the risk, you bear the liability. So what both parties essentially try to do at an arbitration is say, this is a risk that you took on. So you have to be the most convincing person and try to say, this is a risk that you took on. And this is a strategy that we use quite a bit in actual arbitrations. Does it answer your question?
Yes, ma'am. Thank you so much.
I think there's another question.
Yeah, my question is, now that risks have been borne by different parties and now they're liable, that they failed to perform and now they're liable, do certain risks hold more weight, or do certain liabilities hold more weight than others depending on what exactly they are? Like, let's say financial liabilities hold more weight than regulatory liabilities. Is there something of that sort?
In terms of relative weightage of risks in terms of the contract specifically, is that correct?
Yeah.
Okay. So I've been told not to go into the mood problem too much and do your work for you. So I will explain this. I will answer your question and explain it on a more general level. But the things you have to look out for in the contract are specifically in the contract, does it specify who's bearing the risk for what and what exactly has caused the liability? At what point, sometimes in specific contracts, especially construction contracts, they say that up until X point in time, the liability and the risk is borne by one party, and then the risk transfers to the other party. You would then look at, in terms of the risk apportionment, what exactly has gone wrong and who has borne the risk of that going wrong. So let's say, for example, it can't proceed because of, let's say, natural disaster? Who has borne the risk of the contract not moving forward due to a natural disaster? Who has borne the cost in the contract of this force majeure clause coming into effect? So you all know force majeure and frustration, I suppose, of a contract. These are all contract law principles. But if it's, let's say, a natural disaster, you were building a beachside hotel. There is a investment that came in from, I don't know, Poland, for a beachside hotel in, I don't know, the south of Sri Lanka, which they, on an agreement that they entered into with the state, let's say the Sri Lanka Tourist Development Board. All examples. Please, this is not real. And if that is the case and some, I don't know, massive tsunami comes again and hits us and washes away this half-constructed hotel, you then look at who bears the risk for that specific instance, who of that incident having happened. Now, let's say, for example, the state has borne the risk of the environmental impact assessment not being satisfied properly. In that instance, that's not why the contract is not going ahead. Or the company has borne the risk for a performance bond guarantee and securing a loan, and the loan doesn't come through. And that's why the project isn't proceeding. Then that's not going to be borne by the state. So you have to look at what exactly has gone wrong and who bore the risk for that going wrong. But at the same time, you have to be cognizant that if in your contract, there are specific timelines that set out that in the first 3 phases of the project, the state is going to bear all liability. And in the latter 2 stages of the project, the company is going to bear liability. Then that may supersede the specific liability for a specific wrong. So it really depends on how your contract is worded. I'm not sure, but it might be useful to look at whether there are, especially when it comes to construction contracts, there are usually guidelines that are set in place. Like FIDIC, for example, like I think I mentioned earlier, and the SBD for smaller contracts, construction contracts. So there are somewhat guidelines that are internationally accepted. And if you have subscribed to one of those guidelines, then you'd be able to use the principles of risk that are set out in those guidelines. If you're not, I would argue that you could do a quick look at what the general principles are across those guidelines. So even if it's not specified in your contract, you would argue that these are implied terms that are accepted in the industry with regard to who bears the risk for something having gone wrong. Does that make sense?
Yes, that makes so much sense. I do have another question, but it's on something you mentioned earlier. You mentioned that investor state arbitration is not the same as international commercial arbitration. So in that case, does the state have more power, or are they not at the same playing field? They're not on the same level. Does the state have more power? Can they negotiate more? Yeah, that's my question.
Interesting question. So investor state arbitration is based on a bilateral investment treaty. And because it's based on a bilateral investment treaty that is entered into between the 2 states, then you have things that come into effect like what we call a most favored nation clause. So that is where one country might have a little bit more precedence over the other. It's not I don't want to really run into the concept of a most favored nation clause. But just because you've asked, I don't want to run it through. But in a lot of investment treaties, there is this most favored nation clause. The principle is that, okay, give me a second. Okay, so, right. The most favored nation clauses can manifest in a whole different spectrum of ways. It can speak about how the investor is going to be treated in a dispute resolution mechanism. It can speak about how the investor is going to be treated in terms of the specific aspects in the investment process. And it can look at how an investor is going to be treated in the context of the treaty obligations. But like you said, as there is this underlying ideal of non-discrimination, which is that no investor is going to be discriminated because they are an investor and they're going up against a state. But how it works in investment treaties is, when it comes to bilateral investment treaties, is that you have a company and they make an investment, and then we say that what happens is that the state expropriates that investment. It's a little bit different from an international commercial arbitration. I can talk about this till the cows come home, but I probably shouldn't. Does that kind of sort of answer your question?
Yes, that answers my question perfectly. I'll look into it more, and I'm really sorry to steer you off topic. Thank
No,
you so
that's
much.
fine. I'm very happy to talk about it, but there's a lot of jurisprudence on most favored nation clauses. If just to point you in the right direction, there's a few cases, Mafenzi versus Spain, Simmons versus Argentina. And I really hope I'm saying this right because it's from memory. Then there's Consultori versus Jordan, and I want to say Plasma or Plama versus Bulgaria. I think I've gotten all of them, or at least all of the ones that I can remember. But those go into the scope of a most favored nation clause. And if at all, that is the only thing that would maybe consider states versus investors a little bit differently, because this is based on a bilateral investment treaty. And so the terms of the contract are not just the terms of the contract, they also have to encompass the bilateral investment treaty that has been entered into by the states. I hope that's helpful.
Thank you so much.
Is there anything else that I can answer before I move on? No? All right. So the last thing I want to talk to you all about is, last theoretical thing I want to talk to you all about is that I think it was Farah, the last person who asked me the question, spoke to me, is asked about whether there are situations where the state and the investor are going to be not on equal footing. And I mentioned that during the arbitration, they are on equal footing and it is an equal playing ground. But sometimes after the arbitration, there might be issues where the state might have or the company might have a certain degree of advantage. One of these issues can come with regards to the enforcement or the setting aside of arbitral awards, which is set out in the New York Convention, which kind of outlines how the arbitral award is going to be enforced. This might not be a problem for you all at the Moot because you all are actually in the arbitration and you all don't have to worry about what happens after the arbitration and how you enforce the award on the party that is now liable to pay as per the award. But what you might need to keep in mind and what you might want to just remember, just for your knowledge, is that we have what we call the UNCITRAL model law, which is, we colloquially call it the New York Convention. And the New York Convention, Article 34, sets out the substantial grounds on which an arbitral award can be set aside. The problem is, Article 34 of the New York Convention is a little bit wide, and it's up to courts to interpret what that wideness means. So there are some, so one of the grounds is on the basis of public policy, it can be set aside, but the scope of public policy has been defined very differently across different countries. So for example, in Australia, it's any breach of natural justice in the process of the arbitration. In India, it's anything to do with the violation of a fundamental policy of Indian law or a conflict with like the most basic notions of morality and justice, which you all might understand to be extremely wide. So there is a little bit of uncertainty at that point, at the point of enforcement. What does the country that you're litigating in view and define as public policy? Does that make sense? Everyone okay? Anyone have any questions? All right, the last thing is on sequestration of assets, which is just a fancy way of saying, how do I get my money from the state if I've won an arbitration against them? And that can be a bit difficult because you'll have to go to the home country and you'll have to make a claim on their assets. And that can be, it's not that you can't do it, you absolutely can. In places like the United Kingdom, there's a lot of, there are a lot of, I would say, mechanisms in place where you can get injunctions against property held in the United Kingdom. And then that makes it very easy to kind of take the property and claim the property at the end of it. But again, the process on sequestration of assets can sometimes differ from country to country. So that's something that you need to be cognizant of when you are enforcing an arbitral award. That's all I have for you guys on theoretical stuff. Does anyone have any questions? All right, I'm just going to take 5 minutes of your time then, maybe just to give you a few minutes on oral submissions and what you can do to kind of make the process easier. If you've had a coach or if you've got someone mentoring you, you probably already know these things, but just in case you don't, I thought it might be worthwhile mentioning it. You may have heard the adage, you've got to know your bench, not your brief. It's very important to be able to read your judge and to be able to make sure that you are explaining everything to them in a way that they're able to comprehend. Having judged moots before, having coached for moots before, and now being a practicing counsel, both in arbitrations and in open court, I can assure you that a mistake that is very commonly made is that you come with a pre-prepared submission and you want to get through the submission. But sometimes the bench doesn't, or in this case, the tribunal doesn't necessarily follow what you're saying. So you might move to your next point without making sure that the tribunal is completely understanding of the point that you just made. Now, there are what we call a hot bench and a cold bench, which is not a reflection on the temperature, but it is a reflection of how many questions that they're going to ask you. So a hot bench is considered to be, or a hot tribe arbitrator is someone who's considered to ask you a lot of questions. So they'll keep peppering you with the questions. If you feel like the arbitrator is one who is peppering you with questions, perhaps a viable strategy would be to say, okay, yes, these are my points. This is what I want to go into. But what I'm going to right now do is answer each and every one of this arbitrator's questions with the points that I have and that are prepared. So you have to be prepared to go a little bit off script and use the points that you have and fit them in as answers to every question that they're asking. Does that make sense? I personally think when you're being peppered with questions, it's a lot easier for you because you know what they're not understanding and you know what they need to hear from you to be convinced. So you want to use your material as best you can to answer those questions. Do not dodge, do not deflect. More often than not, you can say you need a moment, look through your notes, look through your argument, and make sure that you now have a point that you can squeeze in as an answer to their question. When you are preparing for your oral submissions, my personal experience is that it's not advisable to go with a full script prepared. If you want to have that, please by all means do. But in addition to that, have your main key points jotted down on a separate piece of paper, kind of like a signpost, like a checklist of sorts, saying these are the things that I need to discuss, and these are the things that slot in under this topic, and these are the correlations, and this is the point that I can bring them together. That way, if you're asked a question about X, you would answer with the answer for that, but you'd sneak in a correlation a different point that allows you to segue into another point on your argument. Does that make sense? I'm sure these are things that a lot of you know, if not all of you, are already comfortable with, especially if you've done this before multiple times, or if you've got someone mentoring or coaching you, but just out of an abundance of caution, I want to mention it. Cold benches are a lot harder to deal with. You can't rely on the questions that they're asking you, and instead you've got to just judge them by their body language. Look at their faces, look at if their eyes are squinting, look at their eyebrows, look at whether they seem like they're interested or they seem completely unconvinced. Are they leaning forward in their seat? Are they leaning back in their seat? These are all extremely important things that you need to judge and you need to be aware of when you've got a cold bench. Another thing that you can do is just every time you finish a point, check in. Do you understand? Are you following? Is there anything that I can answer for you? Is there anything that you want clarified again? Force them to ask you a question so you know where they stand. Does that make sense? Everyone's okay with that? The last thing is be really thorough with your brief. I know everyone says it, but if they ask you a question and you need to refer to a document, refer to the document and you need to have that at your fingertips. You don't want to waste the limited time that you have flipping through trying to figure out what is on what page. So it makes sense to have a little index with you where each of the documents and each of the page numbers are listed out so that if you quickly need to refer to it, you can. You also could, at the point of when you're writing this little sketch of what you're going to be saying, perhaps mention the page numbers of any authorities or any evidence that you need to cite. Is that okay? So that's pretty much it from me. Are there any questions before I wrap up?
I have a question.
Yeah.
If, for instance, there is a case on bilateral investment treaty, but there is a principle that we can apply for an international commercial arbitration, are we allowed to do that?
It depends on the contract itself. Now, if, for example, the bilateral investment treaty itself specifies, or that the contract itself specifies that the method of dispute resolution here will be international commercial arbitration, then you will go to international commercial arbitration. But I think I may have misunderstood. You said that if you've used a case law as an authority when it's a bilateral investment treaty, can you adopt it?
Yes.
You can. It depends on the principle that you're talking about.
Thank you.
There are some principles now, for example, if you, because of things like party neutrality, those are things that are, I would say, endemic and intrinsic to international commercial arbitration. So if for whatever reason you have some sort of authorities from a bilateral investment treaty where the state has been given precedence over the investor, then that might not be most appropriate. I'm not saying it won't be appropriate. I'm just saying it might not be the most appropriate.
Okay.
Yeah.
Yeah.
Anyone else? Oh, Yusuf has raised.
Hello.
Yes.
I have a question related to a state investigation. This is somewhat related to the facts. I don't know how much you can speak on this, but say the state has a pending investigation. Can the arbitration board reach an outcome before the state makes their investigation?
I think that's very related to the question, so I'm not sure how much
Okay.
I can answer. I can tell you without referring to law and just tell you that in practice, a lot of arbitrations and arbitral tribunals, the tribunal prefers to let an investigation run its course. But again, it is dependent on who the arbitrators are and what their approach to it is. But in terms of can the arbitral tribunal intervene and do that investigation for themselves, it kind of does depend on whether there is a duality of that investigation. Which is to say, Yusuf, if one investigation is a highly technical, specialized investigation that can only be carried out by a specific body, then arguably you wouldn't be able to have an arbitral tribunal that is not equally as specialized carry out that same investigation. If it is not a very technical investigation, then perhaps you could make an application to the arbitral tribunal to the arbitral tribunal might be able to consider the facts without waiting for the outcome of the investigation. If it's not a highly technical, specialized thing, and they can also lead the same evidence, they also may be able to come to an outcome. But it depends on the context of the investigation. Does that answer your question?
Yes, it does. Thank you very much.
And yes, Matthew?
I just wanted to ask if in practice, the state usually contracts with the system of contract law that governs that state, or are there occasions where you have to use foreign contract law? And if so, like how would you approach that?
In actual practice, usually if you enter into a contract with a state in a particular country, more often than not, the company will agree to run that contract by the state's contract law. But if they don't, then it's just a matter of whoever is appearing for the state just becoming extremely well versed in the contract law of another country. We see this happening a lot. Say, for example, a Swiss company contracts with the Indian government, then whoever is appearing for the Swiss company will have to be extremely well versed in Indian law, if Indian law is the one that is prescribed to. Concurrently, let's say, for example, it is a different scope of contract law. Let's say, for example, it's and I'm just picking random countries out of the hat, but let's say it's Slovenia and China. They've chosen Singapore as their seat of arbitration, and they've decided that they're going to adopt UK law to be completely impartial. Then they'd need to make sure that whoever was representing them at the dispute settlement was very well conversant with UK law. So it does happen where you have counsel who are conversant in a specific legal jurisdiction who appear for a country even though they're not from that country. Does that answer your question?
Yes, thank you. Can I also ask, in international commercial arbitrations, is it frequent that counsel will rely on foreign systems of or unrelated systems that are similar, like with a similar framework? So I mean, like the example I'm thinking of now is, I know apparently, because I googled it, that Sri Lanka as contract law also has some Roman Dutch elements.
Yes.
And so does South Africa's.
Yes.
So if you were I mean, would there ever be a case in which you would be relying on a South African case to try ascertain how certain principles would be applied?
You would. It's very similar to how, for example, in the UK, you would have obiter judgments from Australia or Canada because they subscribe to the same system of common law. So in Sri Lanka, it is common that some of the case law that's on contract law, for example, is based on a similar system like the South African system. And the only thing is, we don't say that those judgments are binding. We say that they're simply persuasive and they are obiter. They just have academic weight. Does that answer your question, Matthew?
Yes, thank you so much.
No worries. Someone else has raised their hand, TC22.
Yeah, thank you, ma'am. I have a similar question to what was asked previously. So, like, the governing law of the contract might be a common law, or could be like the English law, or it could be the Indian law. Now, you see that these countries have a common law system that, of course, they are presidents. But what if let's say there is a common law governing the contract, but what if in the proceedings one uses civil law cases like those from France or Germany? What value do they have?
Again, then none of them are going to be binding simply because they're not from the jurisdiction that is specified, but they will be persuasive, but this will be even less persuasive. So if you are weighing out the case law, if you're weighing out your authorities, it would go binding precedent first. But again, binding precedent in an arbitration on contract law, yes, it's well accepted if it's on a specific contractual obligation. And then you've got similar jurisdictions and then non-similar jurisdictions, which is the least persuasive, arguably, because it doesn't make sense to take something from another system completely. You would be able to use the principles of it, but you wouldn't be able to argue that this is the law. Could argue that this could be considered when making the judgment. For example, there are certain judgments from the US which are not always the most binding, but the concepts and the principles are as persuasive as, I would argue, maybe an academic article. Does that make sense?
Yes, ma'am. Understood.
All right. Is there anything else? All right, Amani, I think that's it. I don't think we've got any more questions.
All right, ma'am. Thank you so much. Before we do move into the conclusion, we would like to humbly request everyone to turn on their videos so that we could take a screenshot of the session for us to remember this session by. And once again, I'm extremely grateful for you for joining us today.
My pleasure. Also, thank you to everyone who asked questions. It made this a lot less boring.
All right, I will be counting down for the picture. Okay, 3, 2, 1. All right. Thank you everyone once again for turning on your videos. And as we come to the end of today's workshop, I would once again like to extend our sincere gratitude to Ms. Nayanthara Balapatabendi for sharing her valuable knowledge, insights, and experiences with us, and for being so accommodating to the questions raised by our participants. We are truly appreciative of the time and effort that she has devoted to make this session both engaging and informative. I would also like to thank all the participants for your enthusiastic presence and active engagement throughout this program. And we hope that the knowledge and the skills gained today will not only assist you in the upcoming 9th Victor's Moot competition, but will also serve as a strong foundation for your future legal careers. And finally, I would also like to express my heartfelt appreciation to the organizing committee and everyone who worked behind the scenes to make this workshop possible. And with that, we conclude today's session. Thank you, and we look forward to seeing you at the preliminary rounds of the 9th Victor's Moot competition. Have a wonderful day ahead.